Thanks for joining us today. My name is Mark Tibbs and I'm the Cyber Intelligence Director at MDR Cyber. So I lead a team of analysts who help our lawyers with investigations. We do things like asset tracing and due diligence. And our team work very closely with our legal colleagues across the firm. And my background is I worked for several years tracking down cyber criminals at the National Crime Agency. And then after that, I spent 3 years advising companies on how to deal with external cyber threats. And I'm joined today by Ty and Sofia, who both worked on the case study that we're going to talk about. So I'll let them introduce themselves.
Good afternoon, everyone. I'm Ty. I am a dispute resolution lawyer working in the private department here at Mishcon. I joined Mishcon in 2013, where I trained, and my practice includes a wide range of complex, high-value commercial disputes.
Hi, everyone. My name is Sofia Berggren. I've been at Mishcon since 2017. Similar to Ty, my area's expertise is also civil fraud and commercial litigation, specialized specifically in injunctive work.
In today's session, we'll be sharing with you some of our experiences from running an in-house cyber investigations team to provide support to our legal cases, but we'll be giving you an overview of the approach adopted by the team, and then we'll be delving into a real case study and an anonymized case study where this team worked together and the cyber team helped throughout. So onto our case study. The following case study is real and it's anonymized. Our client was a business based in London that invested in or acquired other businesses. So this case revolved around what we called a team move, whereby we suspected our client's employees had set up a competitor business with capital backing. And we call this capital backer the investor throughout the presentation. So the case started because of suspicions that an acquisition target had been diverted by the team while they were working at our client. And we suspected that to do this, they'd stolen confidential data from their employer. Our investigation and legal strategy was audacious, but it was fundamentally proportionate. As with every investigation, we think very long and hard about the tools and the techniques we used, and we're tested in front of a court. At the start of the case, our lead partner had been called into a meeting with the client to help address a concern that they had about that staff might be setting up a new venture, and they wanted to know what could be done about it. At that point, suspicions were based very much on rumours, or I've called it rument there in the slide. Before leaving for the meeting, our lead partner asked the MDR Cyber team to do some initial digging. We found social media posts inferring a future venture by the main executive. We found posts that showed the teams were traveling in North America, and also there were some corporate filings on Companies House which showed some new directorships, and this all pointed to an urgency to take some form of legal action. I'll let Sofia talk through the public corporate filings that we found.
So there are sort of 3 steps that we were able to figure out sort of just from looking on public records on Companies House. So the first one was that we could see that the acquisition target that we thought may have been diverted away from our client's business had been restructured immediately prior to the key executives leaving our client's business. So this sort of raised a concern that while the key executives were still employed by our client and they were meant to be pursuing this acquisition target for our client's benefit, it looked as if maybe steps had been taken and things were happening in the background. The second thing that we were able to see through Companies House was that immediately after the key executive's employment period had run out with our client, as in the day after, they took up new directorship roles. The third thing that we were able to see through Companies House was that there were definite links between this investor and our client's key executives that had left. So although sort of healthy competition is part and parcel of sort of general commercial business, the specific timings of these records on Companies House sort of showed that there was something going on here, which was sort of beyond just employees moving on to a new venture.
So our suspicions have been confirmed that from our initial open source investigations and a potential civil fraud claim in mind, that we should do something about this. So the legal and investigations team rapidly assembled to look for evidence of wrongdoing from the client systems. The aim was to make an ex parte application to acquire evidence from our potential defendants at that point. The MDR Cyber team worked with our client's IT team and our e-discovery team, MDR Discover, to understand the technology profile of the client. We quickly found tiny traces of activity, which raised our suspicion further. But after this, and slightly later into the investigation, we looked at the logs from the client's cloud file system, which was Dropbox. And this was one of the key bits of evidence that led us to conclude that their executives had been meeting with the investor a long time prior to their resignations. And so our team went about analysing that information. So we were using our tools and our systems to enrich, to filter, and to sort that data. And by doing that, we were able to identify a handful of IP addresses in the central London area, which weren't the client's offices. And so what this meant was that we were confident the executives at that point had been into the investors' offices together many times as far back as 3 months before their first resignation. And another key finding was that one of the executives had used 2 devices to log into Dropbox, which became very relevant for our forensic inquiries later on in the case. So we'd all put this together just from desktop searches and our client data. And within days of instruction, we were able to assemble this very robust timeline events. And this is what led us to make the application that Ty is going to take us through next.
Thanks, Mark. So alongside the investigations process, the legal team is tasked with analysing, evaluating, and re-evaluating the evidence as it's provided to us. It is an iterative process, but what the legal team are looking for constantly is the tipping point when the suspicions become realised and the case theory really starts to stack up into something credible. Through rumours at our clients' offices, desktop searches, and examining the factual history, including email and telephone records, we've been able to identify the key ringleaders. Through the forensic examination of inboxes and document management systems, that's the Dropbox logs, we were able to identify what was at stake here for the client. And through the analysis of public records and the IP pings and interrogation of email data, we identified that there was a well-heeled investor circling in the market. So by adding all of these ingredients together and enriching it with the experience of the client, it all pointed to a need to take action very quickly and decisively. This is the mother of God moment when the pieces come together and the evidence supports legal action. The aim of the lawyers is to determine what could be done about the developing situation. So the first question is always, what claims are available? In this case study, we had former salaried directors who appeared to be working with a new competitor and have been doing so for some time and at our client's cost. The role of the potential competitor and the investor meant that there were third parties, that there may be a claim in conspiracy. If this was a plot to actively hurt our client's business rather than just set up in competition, then we may be able to make good a conspiracy claim. If the third parties related to the investor or the investor themselves had known about and encouraged the behavior of the executives, there's also a potential claim for inducement to breach of contract and or providing dishonest assistance in the breach of the fiduciary duties. Lastly, because we're talking about data and confidential information, it's worth considering, what is the data and if there's any special claims that may be attributed to that. For example, if the stolen data has been extracted from a protected database, then there may be a separate claim available for the infringement of database rights. I think the second question, but often the bigger one and more interest to commercial parties, is what can be achieved, i.e. what reliefs are available. The courts aren't generally in the business of compensation. The starting point for damages is to place the claimant in the position they would have been if there were no breach of the duties or breach of contract. So one needs to ask themselves whether the claimant has actually suffered any loss from the misuse of its confidential information. It's questions like, could this competitor have materialized anyway? If it can be evidence that the competitor got a head start in its launch by unfairly using our information, then springboard damages may be available as compensation for the competitor's accelerated entry into the market. And if business opportunities have been diverted, there may be a very fruitful claim for damages on the basis of the claimant's loss of opportunity. Another key question to always consider is, who are your defendants? We know who the ringleaders are, it's the former executives, and we know that there are third parties in the mix, the investor. But it's crucially important in these cases where there are so many unknowns still, and the investigations have done a very good job, but there are still information and questions out there, not to overreach. And lastly, when dealing with data theft, there are also important considerations to keep in mind. So they need to be mindful of civil litigation exposure yourself. If it is employees' data that has been lost, do you need to notify them? And finally, what about GDPR, data breach notifications? Our client had 3 aims. First, get the confidential information out of the hands of the former executives. Second, understand what use had been made of its confidential information. And 3, to preserve the evidence so that the extent of the wrongdoing can be understood. Our goal was therefore to secure a delivery up order for the defendants to hand over all documents belonging to our clients, for us to take the images of all of their devices, and for them to tell us what they had done with our data. We successfully obtained that order based on the strength of the evidence that the investigation had generated. The legal team's job, once it has the order for delivery up, is then to execute the search order against that digital footprint that we created. There are a number of practical elements to executing a search or a delivery up. Firstly, to ensure you don't turn up and the defendants aren't there, you're likely going to need surveillance on the targets. With the digital footprint in mind, you need to ensure you have the right tech specialists available with the correct equipment who can quickly take the images. On a practical level, you also need to instruct a supervising solicitor who is independent of it all and just ensures that the search order is complied with and properly executed. Finally, turning up at the doorstep, the execution means serving the order and the evidence on the defendant personally and explaining the terms of it to them. This is the moment when you can break cover. In our case, this was a multi-site operation, and we secured, as part of the order, a gagging injunction, meaning that the defendants were restrained from talking to one another or to anyone else until the order had been executed and the images of all of the devices had been taken. So once you've gone there, you've got the images and the evidence has been reserved and the defendant has delivered up, complied with the order, disclosed the data, it's really time to take stock. Often this means, in our case, starting the analysis anew to fill in the blanks. I think the key step here is to ensure that your case theory still stacks up, and also to ensure that you've complied with your duty of full and frank disclosure. In this case, the disclosures by the defendants that they had indeed misused our data and provided to third parties confirmed and strengthened our concern. And the work put into the investigation meant we were able to successfully defend a discharge application. Obtaining injunctive relief puts you in an incredibly strong position as a claimant. And whilst it's an incredibly intensive period of activity up to securing the order, it's an equally intensive part once you've got the order as well, because now is the time to start turning the screws. There's also a good opportunity to investigate possible new leads. The disclosures may reveal additional third parties that received information, as was the case in ours. We were informed that data had been passed to a number of individuals of which we had not previously been aware. Securing an order can represent a key victory, but quick interrogation of the data that you do secure and that has been recovered can really make the difference.
As well as providing support at the starter cases, the cyber team get involved at disclosure stages as well, not just to help with document reviews, but to apply analysis techniques to disclosed information, to review metadata of the information obtained, and to enrich the review process.
So disclosure is when all of the cards are laid on the table and the partners get to see all of the relevant documents in one another's control. Increasingly, we're seeing that disclosure will generate enormous amounts of data. In our case, we had almost 4 million documents.
We were focused initially on one initial target acquisition business, but during this disclosure case, we were able to see many more lines of inquiry. And once we were given that disclosure information, it was a huge wealth of very, very rich intelligence and evidence to help our case and strengthen our case.
Injunction can be such an incredibly powerful tool. It's often enough to sort of bring about a settlement, to get the parties to someone table to discuss. In boxing terms, although I'm not a boxer, it's a knockout in the sort of first round. I think both Ty and I have been part of cases where the information that we get from a doorstep or a full search has just been enough for the defendants to sort of hold up their hands and come to the table and offer a settlement. Even if it's not enough to bring out an immediate settlement, it's not sort of the immediate knockdown, you still got them down on their knees, which is sort of what happened in this case. I think I'm fairly confident that the disclosure and the information that we got out of the defendants in the beginning of the case with the successful injunction sort of continued to put litigation pressure on them as we sort of went through the proceedings. And then by the time we ended up in the disclosure phase that we just talked about, we had another sort of wealth of information. I think it's important to remember that often when you just start proceedings, you wouldn't get the type of information you can obtain through an injunction until you reach the disclosure phase. So being able to get that up front can be sort of incredibly useful.
in a wrap up, hopefully this case study has brought to life some of the ways that we work together as lawyers and cyber investigators to make better outcomes for our clients. So thanks for listening. If you've got any questions for us, please put them in the Q&A. Otherwise, thanks very much for listening.